Hey guys, and welcome to the Working Money Channel. Wow, take a look at Bitcoin. Bitcoin has really taken off in the last 24 hours, I guess, since I did my video yesterday. And since that point, Bitcoin is up about 10%, just under 10% at 9.64. We did see a high yesterday of about $24,900 for Bitcoin, and right now it's sitting at about $24,500. So we have seen quite the spike in the crypto market. Even XRP is up, trading right now just under 40 cents. Yesterday we did see a high for XRP, just about 40.5 cents. Right now it's trading at 0.3979. So the market is looking good. Cryptos are moving. Market cap now at $1.1 trillion. But Bitcoin dominance creeping upward. Obviously, Bitcoin, the leader of the pack. Bitcoin within the last 24 hours up 9.38. Followed by Ethereum at 7.01%. And we got XRP up 2.99%. So in the last 24 hours, about 3%. Most altcoins are also doing fairly well. So a green market yesterday. Surprising, considering the news we've been getting from the SEC with regards to, the regulation process and the things that have been coming down the pipe. Well, Library here posted this. If you have a crap product, you'll do anything to stop competition. Very symbolic, posting the $1 bill. Clearly, we know the SEC, a branch of the U.S. government, trying to preserve the U.S. banking system, the legacy system. It's getting really hard to hide, I think. This from XRP Darren here on Twitter. Uncle Fester, who is Charlie Munger, by the way, says we should be more like China and ban crypto.
Because it enabled all these convenient exchanges. So if somebody says, I'm going to create something that sort of replaces the national currency, it's like saying I'm going to replace the national air. It's asinine. It isn't even slightly stupid. It's massively stupid. And of course, it's very dangerous. And of course, the governments were totally wrong to permit it. And of course, I'm not proud of my country for allowing this crap, what I call the crypto it's worthless. It's no good. It's crazy. It'll do nothing but harm. It's antisocial to allow it. And the guy who made the correct decision on this is the Chinese leader. The Chinese leader took one look at crypto and he says, not in my China. And boom, there isn't any crypto in China. He's right and we're wrong.
Boy, could this guy be more out of touch? Enigma Ridworld down here saying, they are afraid. They don't want to lose power, and these psychopaths will do anything not to lose it. Or if they lose it, they will cause the maximum possible damage to humanity as a punishment for that. Let's not forget reserve currencies. I mean, none of us are old enough to have lived through several world reserve currencies, but they have changed hands roughly every 100 years or so. I can make a Charlie Munger joke here, but I don't think I will. The point is, does he really not see it? Or is there something bigger at play here as per Enigma Ridworld? Obviously, the powers that be do not want to relinquish power. They are, in fact, psychopaths, and, they will do anything, essentially say anything. Clearly, we know that cryptocurrency has a future. I also happen to see this by Spiritual at Truth Crumbs on Twitter. The good, bad, ugly, and gorgeous. The crypto Wild West is beginning to find its place adjacent to the traditional financial sector. Today and the rest of the week will be action-packed for crypto. So banks are getting the message that they should back away from many crypto endeavors. The next point here, 3 top financial regulators kick off the new year with a joint warning about banks' crypto activity. The Federal Reserve and Office of the Comptroller of the Currency and the Federal Deposit Insurance Corporation on January 3rd issued a blunt declaration that said crypto-related risks that can't be controlled shouldn't be allowed to migrate to the banking system. So, we're seeing a lot of banks step away from the crypto sector, and I think that these banks are, really going to think twice about who they partner with. Again, the next phase of this, banks will likely have to, probably by law at a certain point, only do business with crypto-regulated companies that are registered with, the U.S. government, the banking sector in the U.S., whatever it is, however they decide to frame that. That is going to be the next phase, I think, for cryptocurrency adoption, to keep it on the regulatory path that Gary Gensler wants it to be on. Now, Charles Gasparino posting this, breaking news, crypto execs are being advised by securities lawyers not to act on Gary Gensler's recent call to come in and talk to the SEC about whether their operations are compliant. So securities lawyers are advising their clients now, crypto companies, to not do as Gary Gensler asks. Do not come in, do not go and talk with the SEC, because that's basically going to give them ammo in the future if they so choose to sue the companies that come in and talk to them. They go the reason, unless you're a Dem Party insider like SBF, getting on his radar makes you a target. And Fred Rispoli responding to this hurts me and other early to this message crypto lawyers the most, because I would have gladly accepted $500 an hour to tell this to the crypto execs who are now paying $1,000 an hour for the same message. Coulda, woulda, shoulda, right? John Deaton also responding to this. At this point, one could argue an attorney is committing malpractice if he or she advises a client to voluntarily provide the SEC with anything. So, even going as far as saying attorneys should be on this pointed message so much that if they did give you, if they did advise you otherwise, that would be enough for a malpractice suit. You advise them to honor a notice not to destroy evidence and to comply with a lawful subpoena unless you move to quash it, but that's it. So a huge transformation in the crypto market, a huge turn that we're noticing, guys. Michael Branch here posting this. Another update with regards to the SEC. The SEC is now looking to restrict hedge funds' exposure to crypto with a new proposal. So the SEC has now proposed a draft that would make it harder for hedge funds and private equity firms and pension funds to work with crypto companies. The proposal would make it difficult for crypto firms to hold digital assets on their clients' behalf as qualified custodians, a designation that allows companies to hold client assets for money managers. A 5-member SEC panel will vote on the proposal on Wednesday, deciding whether the proposal will proceed to the next stage. A majority vote will be needed for the rest of the SEC to vote on the proposal officially. If approved, the proposal will be amended with feedback where necessary. And so you would think hedge funds, VC firms, pension funds, they would automatically be approved to hold, crypto assets, to custody these things. But the SEC even wants to regulate that and limit that, saying, you need to use qualified custodians. And who knows what that even means. So an interesting new update here. Wanted to thank Michael for posting that. But the biggest update rattling crypto Twitter this morning, James K. Filan posting this breaking news. Roslyn Layton of Forbes magazine has filed a motion to intervene to petition the court for access to the Hinman speech documents. And so James K. Filan, resident XRP lawyer within the XRP community, he just posted this yesterday evening. It is in a Dropbox, which will be linked in this tweet, which I will put in the description of the video. Attorney J. Carl Caesar has filed a motion for admission pro hac vice on behalf of Roslyn Layton. So all the documentation is in there. Again, it is located here in the Dropbox. James was also realizing that some people were having trouble reading it. So he says that some people were having difficulty on mobile devices. The Roslyn Layton motion to intervene is right here. And guys, here are some of the images. I'm going to read you some of this. Roslyn Layton, PhD, by and through the undersigned counsel, seeks to leave to intervene in this case to petition the court for access to a set of internal SEC documents relating to the speech that former SEC Director of Corporate Finance William Hinman gave in June of 2018. Deemed the Hinman speech documents as, now they have become infamous. On December 22nd, 2022, the SEC moved to seal some of the Hinman speech documents that it offered in support of its summary judgment motion, along with any of those documents defendants might reference in their opposition. Dr. Layton opposes that motion. Dr. Layton, a columnist and regulatory policy scholar, is a visiting researcher at Aalborg University, and executive vice president of Strand Consulting, and a senior contributor to Forbes.com. Dr. Layton, as you guys know, has written a lot of articles about the Ripple SEC case in Forbes. And, she has been a proponent of Ripple XRP, sees the unfairness, I think, and she has, made it her mission to write articles for Forbes magazine about this over the past year or so since since the lawsuit was announced. So Dr. Layton has no financial stake in Ripple or XRP and no special interest in this case, but she has written numerous articles about the Hinman speech documents. In those articles, she has examined the central role those documents play in this enormously significant case, which she has dubbed the cryptocurrency trial of the century, which I could not agree more with. I mean, this Ripple case, this is going to set the stage, guys. This is trailblazing. This is moving the industry forward in the United States specifically. She therefore respectfully requests leave to intervene so she might ask the court to release these documents to the public and to deny the SEC's motions to keep them sealed. Boom goes the dynamite. Roslyn Layton on our team, intervening now, demanding she sees the Hinman documents. So this is the latest news. I don't think we were really expecting this. Crypto Law here posting this. after petitioning to unseal the Hinman documents. Roslyn Layton writes in Forbes, regulators aren't supposed to choose the market's winners and losers, yet it's hard to ignore how securities laws are applied differently to Ethereum compared to Ripple. So what had happened after she decided to go after the Hinman speech and petition to see the documents? She then wrote an article for Forbes magazine. Now, it was interesting because this was all happening very fast last night. When I went to Forbes this morning, you guys can see here, this page is no longer active. We regret any inconvenience. So it looks as though Forbes then took it down. They decided, no, I guess it was too much. And so they removed the page. I guess maybe the contents was too controversial, in and amidst this lawsuit. Crypto Eddie here posted this. It happened again just after we have an intervention by Dr. Roslyn Layton. A Forbes article, Why the SEC Treats Ripple and Ethereum Differently, was removed in the last hour. This is turning into a real dogfight. So other people realizing this. Fojack here just responding with eyes fire. Crypto Boom down here and a few others finding workarounds to actually read the article. To read it, click the link, then tap the lower right corner to have it open in Safari, then immediately tap the AA icon. So this whole process, if you guys want to read the link on your mobile phone, and even the Crypto Basic was commenting on the fact that this was actually removed by Forbes magazine. So do they give us any insight as to why? Forbes takes down this article, Why the SEC Treats Ripple and Ethereum Differently. Unsurprisingly, this has sparked outrage within the XRP community. Forbes has unexplainably taken down the article by senior Forbes contributor Roslyn Layton, which critiques the perceived unfair treatment of blockchain payments firm Ripple and the United States Securities and Exchange Commission. The article titled Why the SEC Treats Ripple and Ethereum Differently is now blocked by a pop-up of an editor's note that reads, this page is no longer active. So we don't even get a typical 404 message. It's a pop-up. You can actually see the article in the background, but there's this pop-up here, as I showed you guys just on this last page here. So you can see the article in the back. However, thanks to screenshots shared by members of the XRP community who disclosed that the article is still viewable, we are actually available to peruse the content. And so if you guys want, I will link this in the description of the video. This is an article from Business News, which basically reprinted the article, but it is in their own words. So it's not a word-for-word representation of the original Forbes article. So I will link this in the description. This is totally viewable. Luckily, though, people in the XRP community have been getting on it, including Thole Better XRP here taking screen grabs from his phone. And here it is, why the SEC treats Ripple and Ethereum differently. Regulators aren't supposed to choose the market winners or losers. Yet it's hard to ignore how securities laws are applied differently to the Ethereum Foundation compared to companies like Ripple. As the Securities and Exchange Commission case against Ripple Labs winds down after more than 2 years of public scrutiny, a judge in the Southern District of New York contemplates whether judges will unseal the Hinman speech documents. The documents refer to a 2018 speech by the SEC Director of Corporate Finance, William Hinman, which, absent explicit regulatory guidance, constitutes the best public instruction for crypto stakeholders to avoid an enforcement action. The speech seems inscrutable. It declares one crypto asset, Ethereum's native token Ether, as outside the securities laws. Subsequently, the SEC launched the case against a similar project to Ethereum, Ripple, seeking billions in penalties for a virtually identical offering that reasonably appeared to fit Hinman's criteria for Ether. As a regulatory scholar, I am concerned about the inconsistency. So this is where Layton actually starts scrutinizing what is happening here. A conflict of interest explanation suggests that Hinman had a financial stake in an entity promoting Ether over competing coins like XRP. Separately, the government watchdog organization Empower Oversight sued the SEC to obtain materials that show Hinman received millions of dollars in retirement payments from his former law firm Simpson Thacher and Bartlett. So, this is all stuff that we have uncovered as the XRP community, the Twitter sleuths working overtime. And, this has been basically 2 years compiling information, drilling down to really kind of see the rot that is going on with the SEC. So Bartlett and that STB joined an alliance devoted to the exclusive promotion of Ethereum, and even that SEC warned Hinman about the appearance of such conflicts. So we're getting more details here. In any event, unsealing the speech documents would clarify whether Ethereum's proponents influence Hinman's speech, while Hinman himself starts the speech by saying that it only reflects his views, not the SEC's. The unsealing could show whether the SEC officials had a view on the matter. Typically, such speeches are approved by agency counsel before going public. Such findings could strengthen the defense's claim that the SEC failed to provide fair notice. If the SEC itself was confused or ambivalent about crypto policy, it follows that innovators and investors could be as well. The case serves as an important referendum on regulation by enforcement as defined by the Carroll R. Goforth in Regulation by Enforcement Problems with the SEC's problems with the SEC's approach to crypto asset regulation in 2022. At issue are critical legal questions of whether the pursuit of enforcement against innovative technologies for lack of compliance and other purported harms are legitimate to use taxpayer resources versus a forthright delineation of policy by the SEC, if not Congress. So then she asks, to seal or unseal the battle of motions. To seal or unseal is a common debate in federal regulatory litigation. Former General Counsel banking regulator Thomas Vartanian explains while transparency protects a free flow of information in the agency process, courts will often be asked to decide if the privilege is being overused. Courts may examine the evidence at issue in camera, so it is only seen by the judge. So you guys remember the evidence that the Judge Torres was going to examine in camera last summer, and that's only seen by the judge, who can determine the legitimate boundaries of the protection with specific knowledge of the information in question. The SEC's counsel moved to seal the documents reflect internal discussions and deliberations by numerous SEC officials that should remain confidential. SEC officials repeatedly expressed their views and it continues down here, express their views and positions on issues of programmatic significance up to the SEC, the ability of agency officials to debate and collaborate with openness and candor would be hampered by the public dissemination of these documents, the motion to the court said. Indeed, the SEC's website lists Freedom of Information Act or a FOIA request or exemption, notably for national security, trade secrets, and personnel issues. The court already determined that the Hinman speech documents are not subject to the deliberative process or attorney-client privileges. It may be a high legal hurdle for the SEC to claim that the Hinman speech was sufficient regulatory guidance and then refuse to make public the backup of the speech. The notion that a regulatory agency could favor one actor at a firm or industry's request demonstrates the concept of regulatory capture, a defining concept in the 1971 Theory of Economic Regulation by George Stigler, who subsequently won the Nobel Prize in Economics. Stigler challenged the idea that regulation is conducted to protect the public, but rather to serve industry. He noted how the SEC garnered the authority to limit selling expenses of mutual funds, thus limiting the growth of small mutual funds and hence reducing the sale cost of large funds. Building on Stigler, my own research of controversial net neutrality internet regulation across 50 countries over the last decade shows a similar trend of established firms, U.S. tech platforms, pressing for regulation to prevent market entry. While such open internet rules are proffered to ensure the next Google, they do the opposite by setting a set price of traffic controls that limit the ability of entrant services and applications to complete and differentiate. Regulation should only be adopted with targeted, limited aims for truly hard problems. Indeed, the crypto industry has consistently asked Congress to develop the needed legislation to clarify the roles of U.S. regulators. Presently, at least 8 agencies assert jurisdiction over crypto assets. So this is the problem here. And then it goes into the disclosure. Disclosure, the author owns no cryptocurrency and has no financial interest in the case. She has no relationship, financial or otherwise, with any parties in this article. And then the disclaimer ultimately ends there. So nothing we didn't already know, in terms of examining this case. As the XRP community, if you've been following my videos over the last 2 years since the case was officially announced, I've covered a lot of this already. Basically, the big thing, though, critical of Ethereum, critical of the SEC, wondering why, just asking the simple questions. Yet, Forbes decides to remove the article soon after it was published. Makes you wonder why, right? Anyways, guys, I will link all this in the description of the video if you want to examine, some of these tweet threads, some of these responses too from people who have also read this. Some great responses here from some respected members in the XRP community. Jeremy Hogan, though, also noticed something interesting. Forbes' own Roslyn Layton has filed a motion opposing the SEC's request to hide the Hinman emails documents from the public. I love how the very first article she cites in her brief is crypto law experts suggest the SEC likely will lose the case. And so he's referring to one of the footnotes here, one of the references that Roslyn Layton did use. And in that footnote, I don't know, can I find it down here? I cannot find it, but it was basically a quote from Jeremy Hogan, essentially stating, and of course I'm paraphrasing here, if the judge does rule in favor of the SEC, she's basically forgotten her whole first year of law school. So that's a very interesting statement. XRP Guerrilla Justice here asking, though, so since they refer to this article, are they technically evidence now? And Jeremy Hogan responding, no, not evidence, but there's no rule that disallows the judge to read opinion articles. So not officially evidence. However, the judge can and likely will read, some of these articles, opinion pieces from lawyers in the XRP community specifically. Lisa down here saying, that is awesome. Wouldn't it be expected that she would have been reading articles anyway? I mean, I would think so, considering this is going to help frame guidance for cryptocurrency clarity in the United States. There certainly was a reason why they decided to remove this article, probably for legal reasons, even though Roslyn Layton was just asking questions. Why is the SEC treating Ripple and Ethereum differently? I mean, it's one thing for us on crypto Twitter to ask the questions, but once it goes mainstream, that's a whole different story. That's just my opinion, but I want to hear what you guys think. Please subscribe to the channel if you haven't already. Like the video if you like the content I'm providing. I always love hearing your comments. See you in the next one, guys.